Hi, everyone, and welcome to the Santa Monica Landlord Tenant Forum. Thanks for joining us. My name is Andrea Kavanaugh. I'm the Consumer Specialist with the Public Rights Division of the Santa Monica City Attorney's Office. We look forward to this event every year, and we'd much rather be seeing you in person, but we're glad you're able to join us today in this format. This has been an extraordinarily difficult year for everyone, and especially so for our landlords and tenants. So I do want to let you know that the Public Rights Division is here to help you in any way we can. Before we get started, I would like to share with you a resource for free mediation services offered by the Strauss Institute at Pepperdine. You can find more information about this pro bono service on our website under the What's New tab. You can find our website at smconsumer.org. So just a quick note about our program today. This program is being recorded and will be available to watch later on the city's YouTube channel. We have a great lineup of topics and presenters for you, and then we'll have a question and answer session at the end. You can type your questions in the chat located at the right side of your screen at any time, and we'll start addressing them about an hour into the program. This platform is new to many of us, and we'll do our best to bring you the program without too many technical difficulties. So thanks in advance for your patience. Now I'd like to introduce Chief Deputy City Attorney Etta Sa with an update on operations at the City Attorney's Office. Etta, we can't hear your sound.
Oh, sorry. Really? Okay. Can you hear me now?
We can. Thank you.
Okay. Sorry. All right. Thank you so much, Andrea. Yes, my name is Edessa, and I'm the Chief Deputy City Attorney of the Public Rights Division. And as Andrea mentioned, I am going to provide operational updates from our division, and I have two types. The first is the COVID-19 related updates, and the other are updates about our division and operations generally. The COVID-19 related operational updates are pretty straightforward. Since March of this year, our office has been physically closed, but otherwise 100% open. Everyone in our division is working remotely during our regular office hours, same hours as before, 7:30 to 5:30, Monday through Thursdays, and every other Fridays. Although letters, complaints, hearings have all pretty much become digital, our phone calls, our services, and operations have continued seamlessly. As for operational updates not related to COVID-19, there are a few that are long overdue. Our name. Formerly, we were known as a Consumer Protection Division. Now we are called the Public Rights Division. In part, the name change reflects a merger of sorts. In addition to all the work that the Consumer Protection Division had been doing, the division is now working with code enforcement to enforce code violations throughout the city. And you can ask questions about code enforcement because we do have one of our officers here tonight. This work was previously done by the Code Enforcement Division of the City Attorney's Office and now has been shifted to the Public Rights Division. As was the practice before the shift, complaints and investigations start with code enforcement. And once code is done with investigation and or the issuance of any citation, we will continue with any needed legal work, whether it's an appeal of an administrative citation issued by our code officers, or the city prosecutes through criminal process or civil action. Despite a new name and new duties, our goals remain the same: to protect the public rights of tenants and to advance the interests of the people of Santa Monica. The division helps tenants and landlords understand their rights and responsibilities and enforces the law through court actions. We handle questions and complaints about the city's eviction moratorium, tenant harassment ordinance, relocation law, fair housing laws, and other housing-related laws, as well as consumer protection laws. And we will continue our close collaborative efforts with the Rent Control Board in shared projects such as this event. As far as the city's eviction moratorium, you will hear more from my colleagues Jonathan and Gary. But the division's current operations as they relate to the eviction moratorium include working with the city attorney and the city manager to provide input regarding the language and the procedures of how the city's eviction moratorium is enforced, providing training materials, drafting and updating summaries, fact sheets, articles, and informational items, working with the city's Emergency Operations Center, rent control, housing, to make the eviction moratorium accessible for everyone. And of course, making available our own knowledgeable staff, Johanna, Bridget, Andrea, who working with side by side with our attorneys will answer your questions, explain the mechanics of the moratorium, and help take complaints. Those are some of the main operational updates to report at this time. But before I pass it back to Andrea, I would like to emphasize that for purposes of this forum, we will not be able to discuss any pending complaints, and we ask that you save that discussion for another time and place. The forum today is an opportunity for us to inform you about some timely issues that impact our tenant and landlord communities, to provide a forum to discuss our public laws and the services that the city and the Rent Control Board provide, and to answer your questions about those topics. We would also like to remind you that we are not able to provide legal advice. Throughout the presentations tonight, you will be provided with information as to where you can get legal advice. And with that, I turn the mic back to Andrea.
Thank you, Etta. We're now going to hear an update on operations at the Rent Control Board from Daniel Costello. There you go, Dan.
Hi, everyone, and welcome to this year's forum. As Andrea said, this is always something we look forward to, and we're very happy to do this again this year with the City Attorney's Office, and to have the participation of the city's planning department this year as well. Even though we're in this unfamiliar format, I think it has a positive aspect to it, and that our audience for this event is actually larger than some of the ones that we hold or have held in person because of the space limitations of the venues. So we'll make the best of this format. This is, one of the ways that we really try to stay connected with the landlord tenant community, and we used to build this as the hot topics that everyone needs to know. Of course, every year there are many new things that come out, and this year is absolutely no exception. Things, locally at the state level. So we ever present sort of a slice of all of the things, and I'm thankful that so many of you came to join us. In the past, many people have come to this event to ask their questions about a particular situation they're in. And we do spend a good amount of time on Q&A, which will be the latter half of the presentation, because the general situations that come up can be very edifying to everyone. And sometimes people need a clarification about the process, the law, or the rules, or enforcement, or your rights. But unfortunately, this isn't a good venue for resolving issues that are very particular to anyone's situation. We can explain the general administrative remedies and the law, but if anyone has something that is a little bit more complex, that would be better handled by contacting one of our offices directly. So we do have the chat open for you to put questions in, and if we don't get to your question today, please feel free to contact one of our offices and we'll do the best we can. So I do want to present how Rent Control has been continuing to provide services despite this horrific year. And I'm pleased to say, as Etta did, that we're really running at full capacity and full swing. So the temporary closure of City Hall has really only had a minor impact on the operations of our department. Kind of most notably, we're not able to to meet with people face to face as we usually do. And as public servants, I think that many of us miss that interaction and the satisfaction that it can bring. And I think that there are probably many members of this audience who may miss coming to see our friendly faces and ask your questions in person. But our department is providing the full range of services we have always provided. And I think a little credit has to go both to the city leadership that has prepared us to be able to work in this kind of environment, and our information services department that has given us the technology. So we managed to make this transition pretty seamlessly, and we hope to continue to provide the best services we can to the public, no matter how we're working. So at Rent Control, our contacts with the public are really on par with what they have been in previous years. Our public information staff, one of whom will join later, Morena Zelaya, she's an information analyst on the team. But they are the ones who have met with people at the counter and answer the phone calls. So they're very busy answering phone calls and emails. We've had over 8,000 calls and emails since April, and that averages to about 1,000 contacts per month. So it's very high volume in addition to all of the other registration processing and things that they do. Initially, we had to send everyone to voicemail when we started working from home. And then we would distribute those calls to the information coordinators and analysts for answers. But Rent Control has always been known to answer calls, and we really pride ourselves on that, and we want to be there for you. It may not be convenient for you to get a call back. So pretty quickly we were able to resume live calling. One adjustment was that we have reduced our hours slightly, partly to accommodate for the increase in emails that staff have to respond to. So now our hours for the phone are from 8 o'clock in the morning until 5 in the afternoon, and we do take a 1-hour break from 1 to 2. So if you call outside those hours, you will get a voicemail, but we'll follow up on that and we will call you back. I'd also just like to mention that Morena and other staff members are bilingual Spanish. And if you're more comfortable asking your questions in Spanish, we'd be happy to have them. Or if you want to refer somebody to us for information, we'll be happy to help them. Our hearings department also has been running at full swing. We initially suspended hearings, but that was for a very short time as we worked out the technology for conducting the hearings by video conference. We're doing all of our mediations by teleconference or video conference or phone. We've even made some unusual changes in that now our investigator will ask the petitioners to guide the petitioners around with their cell phones to record video of specific conditions that we can use as evidence in decisions. The board also recently passed a regulation that would allow testimony by written declaration. So that's new for us, but it's really meant to accommodate some of the parties who may not be that tech savvy. We are working to simplify our processes. We have put a lot of the forms that we have online now as online fillable forms. We're getting just as many petitions as we would any other year. We've had over 24 decreased petitions filed since May, and about a dozen excess rent complaints since the summer. So the hearings department remains busy. Like I said, with the hearings department forms, we also have some other things on our website that people can avail themselves of during this environment. We have an online tenancy registration form that we've had for a little while. That's a really convenient way to do the kind of the thing we get the most of, thousands of those a year, to let us know that there's a new tenant in a rent-controlled unit. We have online registration fee payment available. And we also started accepting digital signatures. So before, we always used to require the wet signature before we could move on something, but now we're moving ahead with DocuSign and other digital signatures. In some cases, we may need you to mail in an original, but trying to move forward in the digital environment. And I should also clarify that we're getting mail. We have staff in the office who are there to process mail and distribute it. I had one owner who had to file a declaration with us, and he thought we weren't getting mail, and he just came to City Hall and slipped it under the front door. But that's that actually got lost, so please count on using the regular mail. We're here for you however you want to reach us, by email or send us a letter. And at the end, we'll put up contact information, but we're really encouraged to everybody here. We'd love everybody to sign up for our email blast. It's a great way for us to reach out to you with important news outside, this channel or our other usual channels. And then later in the program, I'll be back to let you know about some additional components of the interactive information system that we've been working on, and we'll be rolling out more parts of soon. And that will allow you to connect with our department and get access to our records and have visibility into the real-time status of the things you file with us. So we're just full steam ahead, and with that, I'll turn it back over to Andrea. Thanks.
Thank you so much, Dan. I put up a slide, I hope, for that works out. Here's the agenda that we plan to follow today. We have a full program. Please do type your questions into the chat box that you'll find on the right side of your screen. And with that, I'd like to introduce our panelist, planning manager, Jing Yo, who's going to give a presentation on the city's new minimum lease term requirements. So here we go, Jing. Thank you.
Go ahead and share my screen now. Good afternoon. Pleased to be here, and I'm just going to give an overview of the new rental unit leasing requirements that were recently enacted. So before we jump into the details, it's probably helpful to understand some of the why behind why these new regulations were put in place. So there was concern about the negative effects of medium-term housing, and that's a relatively new term to define leases that are between 31 and 365 days. Less than 31 days are considered short-term rentals. 365 is that sort of one-year mark, that ended up being included within the new regulations. There was concern that these medium-term housing leases, largely driven by some probably more innovative approaches to providing housing that we were seeing, conversions of rent control units and the like, and concern that was increasing turnover, affecting neighborhood stability, resulting in higher monthly rents. So all of those issues lead to ultimately limiting the affordability and the access of the city's permanent housing stock to residents. So on September 2019, Council had a study session on these new housing models, and by relation the medium-term housing leases, and gave direction for staff to come back with really an ordinance that was that would protect the existing rental units in residential zones. So what are the new requirements? So this was enacted just earlier this year, and it's effective October 9th, 2020, so just a couple months ago. And it requires that all leases going forward must be for at least 1 year. Units must only be rented to natural persons. Tenants must intend Santa Monica to be their primary residence, and the units must be unfurnished. And it's important to note that this applies to all rental housing units in Santa Monica. There are some limited exemptions to this ordinance. It does not apply to, obviously, units that were lawfully occupied and subject to a lease as of October the 9th until the tenant vacates that unit. Once the tenant vacates that unit, then the new rules would apply. Also does not apply to home sharing, since that is regulated under a different chapter in the municipal code. There were some additional exemptions that were added after the passage of that initial ordinance. Council, asked for public input on that ordinance. We received quite a bit of feedback. It was primarily from owners of largely single unit dwellings, ownership units and the like, who were asking, hey, what happens if I go on a sabbatical, or I want a house swap or something like that. This prevents me from doing that. So that got added as a limited exemption. So in that situation where we have units occupied by owners as their primary residence, you may rent up to 2 times per year, up to a total of 6 months. And as the owner, you have to intend to return to the unit as your primary residence. Please note that the unit, if it has been subject to an Ellis Act, owner move-in eviction, or a buyout agreement within the last 10 years, then it would not be eligible to be exempt from the ordinance. There was also public input received from homeowners who were proposing ADUs, with the purpose of thinking that they could, rent it out potentially for less than 1 year. So council also added in that limited exemption. However, in order to not have that, go on, for a long time, so it's ADUs and junior ADUs on single unit dwelling parcels. So that's particularly on single unit dwelling parcels where the owner is on site for the duration of the lease. The exemption would apply, but the plan check for the JADU or the ADU must be submitted by December 31st. So by the end of this month, basically at the end of 2020 is when that plan check has to be submitted. There's also an exemption was added for certain tenant relocations that are also regulated under the municipal code. So just going to jump now into an explanation of what the tenant and landlord responsibilities are under the new regulation. So as a tenant, your responsibility would be to provide the landlord with documentation that the unit is intended to be your primary residence, and that has to be given to the landlord no later than 60 days following commencement of the lease. As the landlord, your responsibility would be to provide prospective tenants written notice in English and Spanish summarizing these new leasing requirements. And I wanted to note that the notice is available for download. You can see the URL there, www.smgov.net/PCD. There is a link there to a PDF that has the notice in English and Spanish, that you can provide to prospective tenants. As the landlord, you should also retain the documentation submitted by the tenant demonstrating their intent to use that unit as their primary residence, and be able to produce.
Ding, I think your audio has cut out.
Hello? Okay, yeah, I'm not sure why that got muted. So the resources here, again, this is the website, the landing page for the Community Development Department. It has links to the ordinance, so you can read it yourself, and also the required notice. And of course, if you have any follow-up questions at all, please always feel free to email planning@smgov.net, and we would be happy to assist you. So that is the conclusion of my part, and thank you for your time.
Thank you so much, Jing. Again, I just we're getting a few questions in. If you have questions for any of the panelists, go ahead and type them into the chat, and we will do our best to get to them. Our next presentation is a presentation on tenant protections during the pandemic. We're going to hear from Deputy City Attorneys Jonathan Irwin Frank and Gary Rhodes. You're ready to go. Thanks.
Hello, everyone. So again, I'm going to be presenting on tenant protections during the COVID-19 pandemic. I think it's always worth noting right here at the very beginning that I think everyone is aware by now the number of changes that have happened, and I think more changes are likely to happen in the future. So we're all obviously quite hopeful about the vaccines, but I think we still have quite a long way to go. We have been updating the website, santamonica.gov/coronavirus, with major changes relatively quickly. So it's always worth checking that. So just getting started here. This is just our contact information. One more time, again, our new name, the Public Rights Division. I wanted to, some of you may be familiar with this, so just bear with me, but we wanted to go over just some basics of the unlawful detainer process before getting into some of the new COVID-19 protections. So here we have a diagram that just lays out that process. And again, starting at the top with the notice. Now in Santa Monica, as many of you know, there's often an additional requirement for a preliminary notice with an opportunity to cure, maybe for something like a lease violation. And that's something we'll often call an RR notice. You can almost imagine another box above there. One thing I did want to note quickly, and we're going to have a whole other presentation on this, but I think it's always worth saying, you know, the only way to lawfully remove a tenant or an authorized occupant is to go through the legal process. And so that's incredibly important. And so again, the first step there is the summons and complaint. And if you're a tenant, first of all, that should almost always be given to a tenant in person. But no matter how it's received, if you're a tenant, it's very important to respond to that legally within 5 days. Those 5 days do not include weekends and court holidays, but always if you receive those papers, legal papers related to an eviction, it's important to contact and to have an attorney who can assist you as soon as possible. And I think it's also true for landlords, particularly as we're talking about all of the new requirements to seek the advice and assistance of counsel when we're talking about, you know, the very strict requirements in the eviction process. So this here is just an example of what that summons would actually look like. And that's often going to be kind of the first paper that will be handed to a tenant. And again, they would have to respond within 5 days. Okay, so just touching very briefly on the protections available in Santa Monica. Of course, we're all aware of rent control, which applies to most units built before 1979. The just cause requirements, basically you have to be able to prove a reason from a specific list in order to be able to lawfully evict someone. And just cause, that's going to apply to many other units, even those that are not rent controlled. The tenant harassment ordinance, again, for things like cutting off services, evicting someone with just no valid reason whatsoever, or a baseless eviction, and many other things as well. And then, of course, we have anti-discrimination laws, both here in Santa Monica, that does, at the local level as well as the state, that now includes source of income discrimination. And so that means a landlord can't not rent to someone just because they have a Section 8 voucher. And that would also apply to something like receiving rental assistance from a third-party nonprofit. Okay, so moving on to COVID-19 tenant protections. Right now, we're in a world where very often we're going to be focusing on the first two here, the state law, and we'll get into that, AB 3088, the Tenant Relief Act, and also the Santa Monica eviction moratorium. There's also the Center for Disease Control, the federal agency eviction moratorium. It's going to be quite rare that a tenant would invoke that or be able to do so in Santa Monica. But it could be kind of a measure of last resort where the other options aren't available. Okay, so moving on to the Tenant Relief Act of 2020. This is going to be the primary protection when we're talking about tenants that are not able to pay rent due to financial impacts of COVID-19 for the period from March through January of next year. Okay, so we can really break it down into two different periods. The first is rent that became due between March 2020 and August 2020. Now, for this period, there is no payment requirement. A tenant needs only to give or return a declaration of COVID-19 related financial distress. And we're going to explain in more detail what that looks like and how that's done. I will note now, and it's worth repeating, there are many different requirements for what a notice has to include. A 15-day notice for non-payment of rent, which is the new requirement for non-payment notices while this law is in effect. And one of those requirements is that it has to include an unsigned copy of that declaration of COVID-19 related financial distress. So again, for this period, as long as the tenant returns that declaration within the 15 days or has given that declaration, then the landlord can never evict for that rent. And this is just a chart that basically shows how that works. If a tenant does receive a 15-day notice for non-payment of rent, again, that's like the old 3-day notice, but now under the state law, it's required to be 15 days. Then the tenant could either pay and stay, or they could simply return that 15-day, return that declaration of COVID-19 related financial distress, and they would also be able to stay in their unit. Now, the second period, this is from September 2020 through January 2021. And it's going to be the same thing with respect to that 15-day notice, and the landlord's going to have to include an unsigned copy of that notice in any 15-day notice to pay rent or quit. But there's now an additional requirement for this rent. And the additional requirement is that the tenant has to pay 25% of the rent for each month that they couldn't pay and for which they returned that declaration by January 31st, 2021. Now, it's worth noting the tenant can pay that amount in any number of payments and at any time, as long as it adds up to that 25% amount and it's paid by that deadline of January 31st, 2021. And if the tenant does that, then the landlord can't evict them for the remaining 75% of the rent. And just touching briefly on the overlap between this and the Santa Monica protections. September rent is still covered by the Santa Monica eviction moratorium. Now, we do recommend that if a tenant can pay that 25% for September, that they do that. However, they would continue to have until September 30th, 2021 to pay that rent, provided that they've complied with the requirements of the Santa Monica eviction moratorium. And so here again, we have just a graphic that shows the options if a tenant receives a 15-day non-payment notice that covers rent that became due during those months. So of course they can pay and stay, but also if that declaration is true for them, they can provide that declaration and pay 25% or multiple payments adding up to that 25%, and just have to do that by that January 31st, 2021 deadline. And so this here is just an example of what that 15-day notice to pay or quit might look like for rent from that first period from March through August. There are strict requirements for what has to be in that notice. And so it may look like this, but it's not necessarily the case that the format and the font and everything will look exactly the same. And here is just an example of what that notice may look like for that second period. And again, this starts out with a mandatory notice that has to be language describing the protections that has to be included in that. And again, it's worth noting that there are many different requirements for what must be in these 15-day notices to pay or quit for the period that's covered by the Tenant Relief Act. So it is always worth seeking the advice or assistance of counsel. Okay. So what does that declaration of COVID-19 related financial distress, what does that actually include? And you can see that here. And so this is a statement for the tenant, and it is under penalty of perjury. So that does mean it's very important if you're a tenant and you're signing this, the statement is true for you. And it says, I'm currently unable to pay my rent or other financial obligations under the lease in full because of one or more of the following. All right, and I believe that my colleague Gary was going to pick up from here.
Hey, everybody. Thanks, Jonathan. Like Jonathan, I am a deputy city attorney in the Public Rights Division here in Santa Monica. And I also want to thank everyone for patching in tonight to learn more about these laws. And I'm going to start off by going into a little bit more detail about the declaration of COVID-related financial distress, which is also known as just the hardship declaration. First of all, a tenant has to do this under oath, under penalty of perjury, stating that they cannot pay the rent due to a COVID-related reason. And you can see summarized across the middle of this slide the four major categories: loss of income, increase in expenses, child care or family responsibilities, and then the catch-all category of any other financial impact that COVID may have on a tenant or a family's life. So let's go into some examples. If the tenants work in a restaurant that's been closed or reduced hours, and they've got a loss of income from that result, then that's a good reason under this new law. If they have children who are in school, and those children were sent home during the pandemic, and they had to, well, let's go back to that slide, Jonathan, if we can. They need to stay home. They need to take a leave of absence or quit their job to take care of their children while those children are in home learning from home. Then that is a loss of income that can work with this declaration. Similarly, if they decide if they are lucky enough to keep a job and they decide to keep that, perhaps their child care expenses will increase. And that increase in expenses can be a good reason for not paying the rent under this new law. And then finally, and certainly any tenant who either they or someone in their family gets COVID or has to be quarantined and loses income or has increased expenses during that month because of that, that is another reason why you could sign off on this declaration. Now, it's important to note that a tenant only needs one reason to sign this declaration and request this relief through the state law, and they don't have to tell the landlord which reason it is. And if you remember the declaration that Jonathan showed and described to you, there were several reasons there, and the tenant's not required to circle one or underline one. They can just sign off on the whole list and say that one of those, at least one of those, applies. Yeah, there it is. All right. So now let's go to timing. And this is pretty straightforward. 15 days. The tenant has 15 days after getting this notice from the landlord and if they can't pay the rent and they want the state law's protection, they have to get the declaration back to the landlord within 15 days. Now, if the tenant plans on doing this and they haven't got anything from the landlord yet, it can often help to go ahead and send the landlord the declaration. Go ahead and get a copy of that declaration that everybody's using that the state law requires, and go ahead and send that to the landlord. So what if the tenant misses the 15-day deadline? Well, first of all, they should do everything possible not to let that happen. But certainly, if a tenant has a good reason for having missed the deadline, and perhaps they got the declaration ready on day 16 or day 17, and the landlord went ahead and filed the unlawful detainer against the tenant. Well, if the tenant has a good reason, there's a chance that the judge might give them another chance to submit that declaration. Now, if a tenant is in this situation, they should seek legal assistance right away, because this is a new and complicated law, and I think everyone needs help with this. If you are a landlord looking at that situation where the tenant hasn't paid by day 15 or hasn't given you the declaration by day 15, and the landlord has reason to believe that the tenant's trying or has a good reason why not yet, then you might want to consider the fact that if you file this unlawful detainer and go through all this trouble and expense, a judge may still find good cause to throw it all out. And certainly the gist of this law by the state is to protect tenancies during a pandemic, so that tenants are so that our community is not impacted by the evictions. Tenants keep their homes during this emergency. So here we are talking about documentation. The general rule with the state law is that if the tenant fills out that declaration and returns it to the landlord, no other documentation is required. Now, some of you, a lot of landlords and tenants in Santa Monica have already been engaged with one another, because Santa Monica, was one of the very first cities to pass an eviction moratorium. And so since as early as March, you may have already been talking to one another about rent payments, and that hopefully that all worked out fine. But now under the state law, it's a whole new set of requirements. And so even though you've had those conversations, and even though a tenant may have given the landlord a lot of information, we start over again. So for example, for this month, the tenant would need to go ahead and send another declaration to the landlord. And the only exception to the non-documentation requirement is for what's called high-income households, high-income tenants. And the situation has to be this. First, the tenant has returned the declaration signed, and the landlord already has proof that the tenant has an income of over $100,000, or an income of over 130% of the median family income in Los Angeles County, which is pretty close to $100,000 as well in most situations. So if they, for example, if they had an information in their file from the application process that a tenant made $150,000 a year, then at that point, they may ask the tenant for further proof. They get the declaration and they may go ahead and say, well, I'd still like to see, a letter from your employer, or an email, or some proof that you've lost income or had increased expenses. All right, next slide, please. So what happens to the rent? Well, we've emphasized that if a tenant follows these procedures under state law, the new state law, if they have sent in the declaration on time and they pay 25% of the rent by the end of January, then the landlord cannot evict them. Eviction is off the table. However, the landlord is still gets the rent. It's just become consumer debt, and the landlord can sue the tenant in small claims court for that as early as March 1st, 2021. And And you can see here in the slide, of course, that's even the small claims court tenants can raise other defenses, just like they've always been able to fight these claims of unpaid rent. All right, next slide, please. All right, so as I said, there are a lot of tenants and landlords in Santa Monica have already been engaged with one another on this issue, whether that has happened or not, tenants still have to give the landlord a declaration, a hardship declaration. So, for example, this month it's December, and even though a tenant has in the past given the landlord declarations or affidavits or letters from their employer or letters from their child care provider, under the Santa Monica moratorium, which therefore a stretch did require or did allow the landlord to ask for that information. Here in December, this month, each month we start over again, and the tenant still has to provide this declaration, and they should definitely try to pay 25% of the rent by January 31st to avoid eviction. And as Jonathan said, we've got several time periods here, but for the state law period, it started on September 1st, September rent, and goes through to January. Next slide, please. If you want to learn more details about the state law, there's two sources. First, there's our website. Go to santamonica.gov and follow the coronavirus updates till you get to the Tenant Relief Act of 2020. And there you're going to see our attorney's summary of the state law and how the state law interacts with the city's law, and some frequently asked questions answered. The state has also provided a web page or a website, and so you can go to this website here or just Google California and then housing is key, and you'll see their summaries and their resources. All right, so our moratorium with respect to non-payment of rent cases ended in September. And that's because the state law, the state legislature stepped in and said, okay, we're taking over net from this point on. And but our some protections in our moratorium still apply. And these are limits on evictions regarding unauthorized occupants, pets, failure to provide access to an apartment, nuisance, and what we call no-fault cases, where a tenant would get evicted in Santa Monica despite our just cause ordinance and despite rent control restrictions. There were a couple of exceptions, no-fault exceptions, which were the owner wants to move in and satisfies a lot of different requirements for that, or the landlord is removing the building or that unit from the rental market through the Ellis Act process. So our moratorium, Santa Monica's moratorium limits on these are still continue. And in fact, two nights ago, we just extended that to January 31st. We extended by 1 month to January 31st. And I'll go through some examples real quick. Unauthorized occupant. To keep perhaps a household has some aging parents, and they don't want to be running back and forth to another town to take care of them. They want to create a good safe pod with them, so they bring them in. And even though those parents are not on the lease and technically they're unauthorized occupants, and perhaps the landlord in the past would have had an argument that that's a breach of a lease, that a landlord cannot evict a tenant for that right now, at least until January 31st. Pets. same way that those same parents may have had pets, and of course you can't leave the pets, behind wherever they were. So that's another exception right now to evictions. Failure to provide access. This is an important one. This is where owners want to either come in or send workers in to a tenant's home, and in this very serious pandemic, that is a possibility for infection. And so, as a public health measure, everyone wants to reduce those chances. And so, for this time period, a tenant can say no, you can't come in unless there is a very critical repair that's needed for the sake of safety and health, or the property itself is in critical danger. So a landlord cannot evict a tenant in that situation. Nuisance. I'll just mention one example of nuisance. Noise. In this pandemic, one of the effects is everybody's at home. You may have a couple who are both working from home, and their kids are at home, and there's someone right in the unit next door, and there's all sorts of noise emanating from the units and from the buildings. Noise that may have an owner may have wanted to crack down on in the past, but this under this new and temporary limitation, an owner cannot evict based on nuisance unless it's causing a substantial danger to others. And I've already described the owner move-in and Ellis Act issue. So next slide, please. All right, so more information, going back to that same site. If you want more information on Santa Monica's moratorium, it is there. Arguably, the state law allows, after January 31st, if conditions are still serious, we all may look at additional protections for rent. We'll see. We cannot say if or when that will happen, but stay tuned. Now, Jonathan's already mentioned this. The federal government, through the Centers for Disease Control, issued an order that stops evictions until January 1st, 2021. The rule itself says that this doesn't apply in jurisdictions with moratoriums. So this is as Jonathan said, this is a last resort. The emphasis with this rule is not proving that there's a COVID-related issue. It's a public health measure to stop all evictions. So if you find yourself, going to court and you didn't have a COVID-related declaration, or you couldn't sign it, you might look to the CDC order for relief there, and certainly get legal assistance if you're going to do that. Okay, the main takeaways. If you comply with all the requirements, and there's not that many, a tenant cannot be evicted for COVID-related rental debt from March 2020 to January 2021. And the two main requirements are the declaration and payment of the 25% of rent for the months of September through January. Santa Monica's orders that prohibit evictions for reasons other than non-payment are going to be in place at least until January 31st here. And then last resort, the CDC order. All right, here are some more resources for you. The Stay Housed LA has the ability for you to look at information and apply for legal help. The Legal Aid Foundation of Los Angeles and Beth Tzedek, of course, have always been here for Santa Monica tenants in a big way. And if you qualify for their services, you can certainly give them a call. And thank you very much. And we turn it back over to Andrea.
Thank you so much, Jonathan and Gary. Our next presentation is from Deputy City attorney Andrew Braver, who is going to talk with us about two topics, price gouging and self-help eviction. So, Andrew, you are up.
Great. Hi, everybody. My name is Andrew Braver. I am a deputy city attorney here at the city attorney's office, and I hope you can see my slides. I don't know if anyone can shout at me that they can see it or not.
Yeah, it's visible, Andrew.
For now,
thank you.
Perfect. All right, great. So I'm going to be talking about two topics today. The first topic will be self-help evictions, and the second topic will be price gouging. So let's get started. So first I have a pop quiz for everybody. And the question is, what do self-help evictions and price gouging have in common? The answer, they are both illegal. That's right. They are both regulated by all sorts of laws that we're going to talk about. And so let's get into some details here. First, we'll start with self-help evictions. I want to start with the basics here, asking what is a self-help eviction? A self-help eviction is when a landlord evicts a tenant without going through the legal process. As we just discussed, self-help evictions are illegal. There's an interesting question about why are they illegal, and it's helpful to understand the justification behind it. The way the law works, the landlord is the owner of the unit, but the tenant has legal possession of the unit until and unless if the owner evicts the tenant through the legal process. So this means that even though the owner owns the unit, doesn't mean that they have the right to access the unit or to simply remove the tenant unless if they go through the legal process. So what are some of the common examples of self-help evictions? They include landlord changing the locks to the unit. These are often called lockouts, where a landlord will just remove the old lock, put in a new one that the tenant doesn't have a key to. Or the landlord removes the tenant's personal property by taking it out of the unit and placing it on the sidewalk, for example. Sometimes we see landlords trying to gain possession of the unit through violence, or if not violence, through threats. And sometimes landlords will just shut off the gas or other utilities in an attempt to force the tenant out because they can't live there anymore without those utilities. In all of these cases, they're all considered self-help evictions under the law. And because they're all self-help evictions, they are all not legal, as we already discussed. So I want to talk about some of the penalties for a landlord who does a self-help eviction so that both tenants and landlords understand the seriousness of this type of offense. A landlord could be liable for criminal penalties, for actual and punitive damages. That means any costs that the tenant incurred, plus punitive damages to punish the landlord for doing something that is so illegal. And there could be additional charges of tenant harassment that the city of Santa Monica could bring. So in all these cases, the message is these are serious issues, and in legal talk, we would say that self-help evictions are no joke. It is a serious matter. So I want to talk about some frequently asked questions from landlords and from tenants about self-help evictions. From landlords, frequently asked question is, I need to pay my mortgage, so I should be allowed to remove a tenant myself if the tenant doesn't pay. Now, we all understand the need for landlords to pay their mortgages, and if the tenant isn't paying, it makes sense that the landlord wants to get that tenant out of there very quickly and get a new tenant in. From a legal perspective, though, the answer to this question is that the landlord must go through the legal eviction process. The quick way to remember this is that the answer is always the landlord must go through the legal eviction process. So if we look at another common question, some landlords might have this concern, that they need to remove the tenant immediately because they're causing problems at the property. And I want to acknowledge that these problems can be serious, property damage, for example. But the answer to this question, as I mentioned earlier, I gave you all a hint. The answer is the landlord must go through the legal eviction process. The laws are just very clear about this. There are processes if there's an emergency where a landlord can go to a court to receive some sort of help, but in all cases, it has to go through the legal process. So some frequently asked questions from tenants as well would be helpful to go through. The most frequently asked question, of course, is, my landlord did a self-help eviction, what should I do? The answer is call the police. It is that serious of an issue that a tenant should call the police, and the police will respond because, as we discussed, it's illegal. The tenant can also call the Santa Monica City Attorney's Office. The phone number's up there, or you can email us at consumer.mailbox@smgov.net, and we will get involved and also involve the police as well. Tenants also often wonder if there was a self-help eviction, if they can take legal action against the landlord. The answer is yes. A tenant can represent herself or hire an attorney, and there are some additional resources that I'll throw up there briefly. The Legal Aid Foundation of Los Angeles, the Eviction Defense Network, and the LA County Bar Association Lawyer Referral Service. So those are all resources available to a tenant. But most importantly is to get immediate help by calling the police and contacting the city attorney's office. That covers it for self-help evictions. I'm going to talk now about price gouging in rental housing, which is something that's been on the books for many years, but has been now because it's a state of emergency. So first, let's talk about what is price gouging. Price gouging is when a seller tries to take unfair advantage of a consumer during an emergency by greatly increasing prices for consumer products or services. Now, we often think of price gouging for all sorts of consumer products. So after a large, let's say, earthquake, for example, if the price of water goes sky high so that consumers can't buy water, that would be price gouging. But it's not just for water or toilet paper or those types of products. It's also for services, including rental housing. So let's talk about some of the laws for price gouging that apply to rental housing as well. There's a number of sources of law. There's the California Penal Code, Section 396, and the fact that it says penal code means that it is a crime to price gouge. This was recently amended on September 30th, so I encourage everyone to take a look at the recent amendments that have gone into more detail, especially in the rental context, about this type of crime. The California Executive Order has also expanded the penal code in a variety of circumstances, so that's another source of law. And then Santa Monica wanted to get in on the price gouging legal game here, so Santa Monica passed its very own price gouging law that's on the books, and that is in Section 4.32.161, because the city views this as a serious issue for consumers. Let's get into some details here about what are the laws for price gouging and rental housing. The basic law is this. During a declared state of emergency, a landlord may not increase rent by more than 10% of the previously charged or advertised rental price. So that's the basic law. And then it can apply in all sorts of ways. One common question we have from landlords is, well, what if I'm new and I haven't been renting for a long time, but now I want to rent in order to get some income? What is the previously charged or advertised rental price? In that situation, for housing not rented or offered for rent within 1 year prior to the declaration of the emergency, the rental price is 160% of the fair market value as established by HUD, the U.S. Department of Housing and Urban Development. I put that example there just to highlight the fact that there are specific applications for how this works in different contexts. So it's really important to consult an attorney in order to understand how it will work in your particular context. These laws apply to rent-controlled units and non-rent controlled units. The state law, for example, doesn't distinguish between them. It's for all consumer goods and services of this kind. And these laws also apply to units that are rented daily, such as Airbnb and VRBO. So for price gouging, I want to go through a couple FAQs from landlords and tenants, just like we did earlier. From landlords, the main questions we get are about exceptions, and there are a couple important exceptions. One question is, well, what if the landlord wants to increase the rent by more than 10% to cover an unavoidable increase in the cost for repairs? You can imagine a number of situations where an emergency might require repairs, which are unusually expensive because of the nature of the emergency. In that situation, a landlord may increase the rental price by more than 10% if the landlord can prove that the increase is directly attributable to those additional costs for repair beyond normal maintenance. This is an extremely narrow exception. So the landlord really has to be able to prove that and prove it in court. It's not sort of a big loophole for landlords to jump through. The other question we get is, what if the landlord and the tenant contractually agreed to a rent increase of more than 10% before the declaration of emergency? In that case, the landlord may charge the previously agreed to rental price. Move over to some FAQs from tenants. The most frequently asked question, of course, is tenants seeking help. My landlord increased my rent by more than 10% during an emergency. What should I do? The answer is to come talk to us. You can file a complaint with the Santa Monica City Attorney's Office. One way to get to our website is www.smconsumer.org. And in the top right section, there'll be a button to click for submit a complaint. Go ahead and click that button, enter your complaint, attach as much supporting documentation as you can gather, and we will investigate it and work with you and your landlord to resolve the matter or to take legal action if appropriate. Because it's also a state law, you can also file a complaint with the California Attorney General's Office. Their website is oag.ca.gov, and they also have a place to click to file a complaint. What are the penalties for a landlord who price gouges? This slide will look very familiar because it's all the same possibilities we discussed earlier. A landlord could be liable for criminal penalties, actual and punitive damages, and additional charges of tenant harassment, which means price gouging is no joke. Okay, so those are the topics to discuss. I have some almost final thoughts to share before my time is up. First, we encourage landlords and tenants to learn about their rights and obligations. It's always good to educate yourself, to educate each other, and to be knowledgeable about your own rights and your obligations. We also encourage landlords and tenants to work together with kindness and good faith to resolve any misunderstandings. A lot of times, some kindness and good faith will go a long way to resolving a dispute that might just be based on a misunderstanding, where some good communication can help resolve that. And we are here to help. You can visit the city's website at www.smgov.net, where you can access all sorts of information from the Rent Control Board to the City Attorney's Office and so on. And for my actual final thoughts, I just wanted to say thank you to the landlords. We appreciate all you do for tenants and the community. And thank you to the tenants. And we appreciate your contributions to make Santa Monica a vibrant and engaged community. We are here for any questions from landlords or tenants or anyone else in the community. And we so much appreciate how engaged you are and look forward to hearing from you. Thanks.
Thank you so much, Andrew. Our next presentation is from Daniel Costello, the Public Information Manager with the Rent Control Board, who's going to give us some information about Rent 2020, the Rent Control's interactive information system under development. So go ahead, Dan, and take it away. Thanks.
Thank you. So let me share my screen with you. I'm having a little trouble sharing the slideshow, so let me just go about it a different way.
Do you see where to share it from, Dan? If you go to content sharing, you should see share screen.
I do, and I see either the entire screen or the actual applications that I can share.
Right. So if you click on, you have to click on a window within. So if you click on application window, click on a window within there for whichever application, or if you share your entire screen, you have to click on the screen, and then it should let you share.
Right. I am doing all those things, but it's not allowing me.
What's your asset tag on your laptop? Can log in and help you.
This would be a PowerPoint presentation.
But on your laptop, there's a sticker that has some numbers, letters and numbers on it. So I can log into you.
Oh, at the bottom. Okay, one moment. So that is LP 3182.
Did you say LPF is in Frank?
Yes.
Oh, F 3182.
It's a good thing I gave some kudos to our IT department because I'm getting help now from somebody there. So
yeah, you know what? I'm not seeing your computer listed though. So tell me exactly what you're seeing. You see.
Actually, Corey, why don't we take some questions while Dan gets his issue worked out online? Is that okay? Offline?
Perfect. Dan, I'm going to Skype you.
Okay, and just wanted to begin with a correction to something I said earlier. Morena let me know that our office hours are not, or our live phone hours don't begin at 8 o'clock, they begin at 8:30. So I don't want to disappoint any early risers or something. So.
Okay, we'll come back to you, Dan. Send me a message when you get your stuff worked out. I'm gonna so we're gonna take some of the questions from our participants. Thank you again for including your questions, and I'm gonna put our presenters back with your cameras on. So here we go. Hope everybody is still with us. So I want to introduce some of our panelists, and then we have a few people joining us as well. We have from the City Attorney's Office, we have Chief Deputy City Attorney Ed Assa. We have Jonathan Irwin Frank, Gary Rhodes, and Andrew Braver. From Code Enforcement, we have Maurice Kochi. From the Rent Control Board, we have Morena Zelaya. And I think that is everybody. I'm going to put everybody up here. I hope we can see everybody. And our first question is, we're going to address it to Andrew because it's related to the presentation he just did. And here's the question. I'm a tenant. The owner is selling the condo. The buyer can raise the rent to whatever they want after 1 month, even though the place is rent controlled. The buyer has contacted me telling me they're raising the rent from $2,000 to $4,000. Can they raise my rent this much during a state of emergency? What happens if I can't pay the rent? Will they evict me? Will I have to pay the money back if I don't pay the full rent? That's actually about 10 questions, but Andrew, I know, can take them all on.
Sure. Great. Thanks for that. I see at least 3 parts to that. The first part is about rent control and whether this unit is under rent control. That could be a complicated question for condos, depending on when the tenancy began and and the history of sales. So for that question, the best thing to do is really to contact rent control or contact the city attorney's office. We can get all of those details from you so that we can give you some good guidance there. And I should say really from the beginning, just to make it clear that in this forum, we can't give legal advice, and in fact, we can never really give legal advice. We represent the city, not individual tenants. But this is only for public information, but we encourage you to contact us and follow up so we can give you the appropriate information for your specific circumstances. So for that first part about rent control, please follow up with us and with rent control so we can figure out all the relevant facts to make sure we give you the correct information. The second part of the question seems to be about possible price gouging, because that's certainly an increase of more than 10% to go from 2,000 to 4,000. So that would be a good situation for you to contact us at the city attorney's office by going to www.smconsumer.org and clicking on the submit a complaint button. We'll get that complaint, we'll get back to you quickly, and then we can follow up with you and the landlord and take any action that's called for. And then the third part of the question is, what if you can't pay it? whether or not that amount of increase is legal, there may still be some increase. And if you can't pay it, that goes to what Jonathan and Gary spoke about. There are protections under the state law. So I won't go through it again since Gary and Jonathan did such a great job. But if you have further questions about it, please do contact us and we'll help you with your specific circumstance.
Excellent. Thank you, Andrew. Our next question, I'm going to ask Maurice to respond from Code Enforcement. This is the question. In wake of COVID-19, the health and safety of our community is immediately threatened by the lack of enforcement of short-term rentals. In addition, numerous rental units are illegally occupied as short-term rentals. How Maurice, can you explain to us how Code Enforcement is prioritizing their work right now and how the public may expect enforcement of short-term rentals now and in the future?
Yes. Can you hear me?
I can. Thank you.
Okay. Yeah. So currently, right now, all of Code Enforcement, we are assigned to the EOC to do COVID-19 emergency order enforcement. So we're out there. We're going business to business, making sure that the businesses are complying with the with LA County's public health emergency order. Also, we are doing face covering details. We're checking on gatherings. We're doing all this stuff with the emergency. But in addition to that, we are addressing concerns that are life safety issues, that are immediate life safety issues, and we prioritize those concerns and how severe that they are. And at this time, short-term rentals is not a high priority for us. And I do want to say that if someone believes that someone has COVID-19 or that is infected, they should contact public health, and then report that. Also, everyone should be, practicing their social distancing, and they should be wearing their face coverings just to help reduce the spread of COVID-19. But at this time, Code Enforcement, we are prioritizing all of our calls, and we may not get to doing short-term rental enforcement as soon as possible, but we will eventually start and enforcing it. And if anyone has any questions or concerns, they can go ahead and give us a call at 310-458-4984, our main number, or they can email us at code.enforcement@smgop.net.
Excellent. Thank you, Maurice. Our next question I'm going to ask Etta to address. It says, what actions will you take when a landlord has failed to notify tenants of required moratorium protections? And if a landlord deceives tenants of their rights?
Looks like you might be.
I think you're muted, Etta. We can't hear you. You're not muted, but we still can't hear you.
Etta, I think you might have the wrong audio device set up. If you click on the gear icon in the lower right-hand corner of your BlueJeans window, and that will bring up the different devices. If you choose whichever one you want to be your microphone, we should be able to hear you that way. We still can't hear you.
Actually, could we ask one of our...
Yeah, I'm happy to...
Go ahead, Andrew.
I'm happy to jump in while Etta gets her mic going. So under the city's eviction moratorium, there is a notification requirement for tenants. So that is part of the city's law. And also part of the city's law is a prohibition against landlords deceiving their tenants about their rights under the law. So if that's occurring, please do contact us and we will follow up with you.
Excellent. Thank you, Andrew. I think Dan is ready to go with his presentation for rent control. So we're going to hop back in. Sorry to interrupt the questions, but we want to make sure we have time for the presentation on the Rent Control 2020. So I'm going to ask our lovely panelists to hang out for a minute. We're going to put Dan back up, and we're going to turn your cameras off for just a few minutes. Thanks everybody for going with the flow here.
All right, so are you seeing my screen now?
Yes, very good. We're ready to go. Thanks.
Okay. So I'm really happy to get to this point. I'm introducing Rent 2020, which is a set of applications that we've been working on for several years, really because we have to replace our legacy database that we use for tracking rents and keep track of property ownership. If you've ever gotten a printout from us of our database, you know that it's rather dated. It's written in COBOL. So internally, this is also going to help us because we're going to be able to integrate several siloed databases that we have in one comprehensive system. So Rent 2020 is a collection of web-based tools for property owners and managers and tenants that will improve the visibility and streamline our operations. It will allow you to easily look up what's in our records, get very focused information on what you want to see, submit forms electronically, and you can track their status as we process them, so you know exactly where we are with it. And we're going to prepare plain language reports. Our current system identifies things like separate garage amenities as a 4. Well, without a legend, it's very hard to know what that means. So we're going to try to provide landlords and managers and tenants, anybody that's interested, just plain language information about the properties where they live or own or manage. So there are 3 components to it. Look up a rent, our document portal, and something called a rhythm application. The first 2 of these are actually already live, and I will give you a quick demonstration of them at the end. But first, I'd like to introduce the rhythm application. So this is what it looks like, and although the pictures may change, but everyone will need a login. So we have, in our newsletters and on our website, we've asked people if you're interested in having a Rhythm account so that you can file things with us electronically, then we do need to have your email address and the properties that you would like us to associate you with. That is particularly for property owners and managers and not for tenants, but tenants can use the system just as well. So the system, once you log in, you'll have a dashboard, and it will allow you to do various things like submit a record, or you can look up, what's going on for the properties that you own or manage, and you can have several properties up here at the same time. And this will allow you to electronically file a lot of the things that we've been getting on paper for years. So the typical forms we get, probably the most common one is the tenancy registration form, but sometimes there are added amenities that have to be registered, or changes in the owner's mailing address, or their authorized agent. But you can also use the system to file fee waivers. If you're a low-income disabled tenant or senior tenant, we offer a waiver of the rent control fee. You can use this to file all the different petition types that we have. What's nice about it is that it also will allow you to attach documentation, and then we can index that and route that right into our document management system, and you'll be able to see the records that you've submitted. So it's really great. And as you go along, so everybody would have a dashboard, and it will identify for you the various forms that you have filed, the tenancy registration form or added amenity form, and where it's at in the process. It's easy to search through the system. So if you, for example, are a property manager and you manage 20 properties, there's a way for you to go in and search by the street address. Or you can search by the document type that you filed, or a range of years of things that you may have filed. And it will return the applications that you filed with that are in this system. So it's something that's in development, but we plan to launch really in the springtime of 2021, and we're really looking forward to it. Again, to get started, we do need you to send in a request for an account. We set up this special mailbox for that. It's rent2020@smgov.net. We'd like your name, and if you're a property manager, the properties that you own or manage, and then we'll contact you as soon as we're ready to launch. And we want everybody to know that this is a new system, and we know that will be unfamiliar to property managers, and we're happy to provide training and support when we get to that point. So last, I'd just like to show you a couple of the other components of Rent 2020, and that's our Look Up a Rent feature on our website and our document portal. So let me change my screen share. Just go to my entire screen. So this is the rent control website, which is smgov.net/rent control. The city is revising all of its web pages, but you should be able to reach us here, or we'll direct you to this page. And on the left-hand side, on the right-hand side, in this rental units box, we have this feature called Look Up a Rent. And this isn't really a new feature, but we did augment it this year. And it allows you to go in by street address and search for a property and have it return to you the rents that are currently registered with rent control. The system gets updated every night, so it's not live, but it's pretty close to live. There are some particular ways that you have to enter the street address, no periods. 9th Street is 9th Street, not 9th Street or 09 Street. But once you click on it, it's going to give you what the rents are for all of the units on that property. The augmentation this year was to also provide the tenancy date. And this is important for property owners and managers to know whether or not they have registered the most recent tenancy. If they haven't, they'll need to do so. If there is a generally will mean that this tenant moved in before January 1st, 1999, when the registration of tenancies was generally first required. So this is it's a pretty simple system, very easy to use. And now let me show you the document portal that we have. So I'll go back to home. And then again, also on the right-hand side, we have these quick links to our document portal. You can just click on that. And this will take you to an area where you can search all of the documents that Rent Control has scanned and filed for all of the controlled rental properties. Currently, we only have 2005 to the present, but that's a pretty good chunk, and we'll be adding to that as we go forward. So I'm just going to look up a property here, the address number, and then the street. We made this a little bit easier this time because you don't have to meet a certain convention. You can just go in and it'll provide a drop-down list for you. If you know the year of the document that you're looking for, great, you can enter that here. But otherwise, you can just search all of the documents that we have for this property. And this is a great way to do some self-research. So as you can see, there We have lots of columns of information here, generally the property address. And each one of these columns is actually, you can sort it. So if you want to do it by document detail, you can do that. All the documents will appear together. You know what you're looking for. Or if it's by year and you just want to pick something that's recent, like, for example, here is a decision on a hearing that was held. And so once you click on it, this is probably a fairly long decision because it's taking some time to load. But this is our database and some of the internal markups that we've done. But here's the actual decision of the hearing officer. So this is a really convenient way to look at our records. And I will just stop there. But as you see, there are really a couple of easy tools that everybody can use. And we hope you will use them. Thank you.
Thank you so much, Dan. We have a few more questions. I'm going to put our panelists back up, so I thank you for your patience for 1 second while I'm turning everybody's video back on. Hope you guys are ready. Isn't this fun? When I turn on your camera, when you're not expecting it. Our next question, I'm going to ask Maurice and Morena to both address this question. Morena, I think okay, we're ready. So this is our question. Who do I contact for excessive construction noise in an adjacent apartment? There's no posted notice of remodel. The same thing happened last year for 3 months. Any contact information is appreciated. Can we get Maurice to address that? Actually, Morena, can you take that one?
Yeah, can you hear me? Okay, so you can definitely contact code enforcement, and I'm sure Maurice will talk more about that once we get to sound working. But with rent control, if you're in a rent controlled apartment and there's construction happening in your building, then you should definitely contact us, and our contact information will be up at the end. We have a decrease petition that is specifically geared towards construction impacts. So if this is happening, if you're not receiving notice, if this is impacting your ability to live in the unit, in your unit, that's something that we may be able to address. So we would ask that you give us a call or send us an email and sort of explain to us what is it that's going on, provide us with your address. And then we'll start looking into it through our different databases and make a determination about whether or not we would send out a notice to the landlord that we've been informed that construction is happening and that tenants may be able to file petitions. So we know that, especially right now with the pandemic, everyone is home and construction can be pretty cumbersome. So we encourage tenants to contact us if they have any concerns about what's going on. And I'll see if Maurice is available.
Can you hear me now?
We can.
Hello?
Yeah. Thanks. Go ahead,
Okay.
Maurice.
All right. Sorry about that. Yeah. With code enforcement, you should know of any type of construction that's going on in your building. Normally, once a permit is issued, there's what's called a means and methods plan that has to be completed by the contractor or the owner, and then they have to give that means and methods plan to each tenant that it's affecting. You can guys, anyone that has any concerns about excessive construction can give code enforcement a call. We will check it out. We will make sure that there's proper permits. We will make sure that a means and methods plan was completed. If it is affecting any of the tenants. Also, there are regulations when it comes to tenant protections during construction, which I believe is on the city's website. and then if you can't find them, you can reach out to code enforcement, and we will forward that over to you guys. But other than that, yeah, just reach out to us, and then we can investigate it as soon as possible.
Excellent. Thank you, Maurice. The next question I'm going to address myself really quick. The question is, I am a landlord and have hired an attorney to interact with my tenant who has not paid rent since May 2020. How would landlords be notified if there were to be any additions to the current Santa Monica eviction moratorium? And Jonathan covered this already. We have a website about the eviction moratorium and another FAQ about AB 3088. And we've been, Jonathan especially has done a great job of updating that website as changes have come to the moratorium. And you can find all of those pages at the website santamonica.gov/coronavirus. And those updates go up almost in real time. So I think, okay, so we have another question. This is for Morena. It says, landlord filed a new tenancy form with the market rent. I've been living in my apartment for several decades. It's been a year since I first told the manager. How should the manager fix this? And there's more, this is a three-part question. If I can't work this out, would this issue be in the jurisdiction of a rent decrease petition? And if the manager does not approve my request for a wheelchair ramp, who in the city would we contact? So I'm going to ask Morena to address the first 2 points of that question.
Yep. So if your manager has inadvertently filed an incorrect X form, an incorrect tenancy registration form, they can definitely use our online portal, one of the portals for tenancy registration that we have on our homepage, in order to rectify that problem, so they can submit a new registration form. They would contact us to let us know that the previous registration form was filed inadvertently, and hopefully it's as simple as that. We'll remove the previously submitted registration form that's incorrect and just fix it. Well, actually, we would just remove it because you said that you've been living there for 10 plus years, so it's just an incorrect submission. So, and then once you start getting more mail from us, they would go back to what your maximum allowable rent would be. So it would be all, the mail that you get from us would be tailored to your tenancy. If that doesn't work, if they're not willing to contact us to remove that registration, and they serve you with a rent increase notice, even if the rent increase notice is appropriate to what your rent should actually be, you can contact us about a potential excess rent petition, because in order to increase the rent, landlords must be in compliance with the rent control regulations. And if the registration is incorrect, then the landlord's not in compliance. So we encourage you, and we encourage the landlord to try to fix this just by simply sending us written communication to let us know that this was done in error. But if that doesn't work, you can always the tenant can always contact us about a potential petition process. Is that both questions, Andrea?
I think so. And then the third part, I'm going to ask Gary to address this. If the manager does not approve my request for a wheelchair ramp, who in the city of Santa Monica would I contact?
If the landlord has denied that request, they should contact our office and file a fair housing complaint, and we will investigate it. Another resource besides us on an issue like that would be the Disability Community Resource Center. They have not only experts that can help the tenant and the landlord figure out what's the best approach for a wheelchair ramp, but they have sources, fund sources, including from our city, to help the two parties pay for that.
Excellent. Thank you. Gary, this question I think would also be for you. It sounds like a specific legal issue, so I'll let you decide whether or not you can answer it. Does a landlord have a reasonable expectation to know who is living in an apartment? if the legal tenant is out of the country but persons are occupying the unit, can the landlord knock on the door for the identity of the occupants?
Oh, wow, that is very specific and, and interesting. I think they should contact their attorney on that issue. The landlord should. Of course, there's Section 1954 controls when a landlord can enter the home or request, to come into a home. I know that knocking on the door may not qualify, but once an owner is going to a unit and trying to, dig up information or in other situations digging up dirt, they have to have given the tenant notice for occasions like that.
Okay, thank you. Well, this is our last call for questions. We're coming toward the end of the program. I'm going to ask Jonathan, I think, to answer this next question that came up. And I think this questioner is asking about a condo unit. And it says, can we sell the apartment and still be compensated for the thousands of dollars owed? And I'm assuming this person is asking about deferred rent.
Yeah. So in terms of rent that's deferred under the Santa Monica eviction moratorium, that would still apply. That is the extended time period to pay that rent. That protection will apply even after a tenant has moved out. And even whether or not it was sold. So they would have that entire year to pay, and they could raise the eviction moratorium as a defense, even if that were a civil case seeking to collect that rent.
I think they're asking if the owner can sell the unit and still collect the deferred rent after the unit's been sold. I don't know if that's a question you can address.
Yeah, I don't know if any of my colleagues have insight on that. I mean, I think maybe that is another question where they should consult with their attorney.
Okay, this next question is for Andrew. It is about price gouging. It says, if a legacy tenant paying $600 a month vacates voluntarily, can the landlord charge market rent of $2,400 on a refurbished unit?
Yeah, I mean, that might actually be a better question for Morena. I don't know if you want to take that. It sounds like a rent control question. Oh, I see.
Would you specifically address as a price gouging question?
Yeah, thanks. Yeah, so for price gouging, the price is the previously advertised or offered price. That's the base rent. That's the way the law is written.
Okay, I do not. We have breaking news. A question. This is a question about the midterm lease requirements, the minimum lease requirements. I'm going to ask Etta to address this.
Sure.
If a tenant needs to break, I'm not actually sure this is about the midterm question, but I'll ask you to address it anyway. If a tenant needs to break the lease because of a change in living situation, or if they have a family medical problem, how does that affect the new restrictions? Are there any repercussions for the landlord?
I think the minimum lease requirement looks to the actual lease at the beginning of the term. So if in the beginning, as the landlord and the tenant are negotiating, if they meet the minimum requirements, that is kind of where the law is enforced, or it's complied with or not. The minimum lease laws, the new laws, they don't necessarily address what happens in between, but it does look to the time that the lease is negotiated, as well as the obligations that Jing had talked about earlier, within 60 days, the tenant has to comply with providing the primary residential residence documentation. The landlord also has certain obligations, but once those obligations are met, and if things, especially if there are unexpected circumstances arise, then that doesn't appear to be a violation. So I'm not sure if that answers the question, but the law does look for compliance at certain periods. And if you're 9 months into the lease and you need to leave, then so be it.
Excellent. I think those are all of our questions, unless any of our panelists have anything to add. I'm going to put up a slide with our contact information for all of the departments who have given us information today. And I really want to thank all of our panelists again and our attendees. It's been wonderful to be able to meet with you in this limited way during this very challenging year. And the contact information is on the screen. All of these departments are available to take your questions. The city's coronavirus website is listed at the bottom, where you can find updates to eviction moratorium and other tenant protections. So I'd like to thank you again for joining us for the Santa Monica Landlord Tenant Forum, and we hope to see you in person for this event next December.
And before we break, Andrea, I do want to say thank you so much to Andrea, as well as Dan. But Andrea, she took this project on this year and under very unusual circumstances. And I have to say, between the coordination and the organization and even the technology, thank you so much. We couldn't have done this without you.
Thank you, Etta.
Yes, thank you, Andrea.
Thanks.
Thank you so much. All right, so we're gonna end the event now, and thank you everyone for participating. And please follow up with our offices if you have questions. Thanks for joining us.
Thank you.
Bye.
Bye.